Okay, let's go. And Kita and I are happy that everybody could join us today for this lunchtime webinar. As a brief intro, and Kita is a young, intelligent, energetic 2020 call whose practices focuses on AB. My practice is a little broader in scope. I do all insurance defense related matters, um, of course, including AB. SBA has three offices in Toronto, London, and the Kitchener Waterloo area, giving us a breadth of flexibility to assist you wherever your insurance needs may take you. We also have some experience with dog walking. If you need help with that, we can do that too. I believe that this presentation is being recorded and is going to be online on our website within the next couple days. If you want a copy of the slide deck, please contact either myself or Ankita, and we'd be happy to provide those to you, to provide that to you. Or if you have any questions after today's presentation, we'd be happy to field those questions as well. There will also be a question and answer period if we have some time at the end. I believe that the button is at the bottom of um, the Zoom page. So just plop your questions in there and Ankita and I will take a look. So without further delay, I'm going to jump right into it. Today, we're going to chat about the sea change that we've seen with respect to Section 32 of the SABS. So what does the SABS say, or what did the SABS say? Section 32 of the SABS relates to the notice and the initial application for accident benefits. And there are two important or distinct timeline requirements that we are going to discuss today. The first is subsection 32(1), and that says that a person who intends to apply for accident benefits shall notify the insurer within 7 days of the accident or as soon as practicable possible. This section has been discussed most in the case law because oftentimes when we're dealing with a late application, we're effectively dealing with receipt of the OCF1 as the first notice that the insurer has of the accident or of the loss. The baby brother subsection, I'll call it, is 32 sub 5. It's equally important. We've seen some case law with respect to section 32 sub 5 as well, and it says that a person shall submit a completed and signed OCF1 within 30 days after receiving the application forms from the insurer. Now, the language in the SABS is quite strong. Both subsections use the word shall, which basically means, in layman terms, it basically means that you have to do something, you must do it. But because the SABS doesn't like to make anything straightforward, there is a saving provision, section 34, and it says that if a person has a reasonable explanation for failing to comply with the timelines in section 32, then they may still be entitled to benefits. Reasonable explanation is not defined in the SABS, but we do have case law that's helped us interpret what reasonable explanation means. There are guiding principles that we have in deciding what constitutes reasonable explanation. And to start, it's important to note that guiding principles is much less stringent than a legal test. It provides an adjudicator or a trier of fact with much more leeway in deciding what reasonable explanation means. There are 5 or 6 guiding principles that we use. The first one is the big one, credibility of the claimant in deciding if their explanation is reasonable. Credibility is really big when a trier of fact is looking at a reasonable explanation. The second prong or second guiding principle is the onus is on the claimant. It's not on the insurer to decide or to provide a reasonable explanation. Number 3 is that ignorance alone is not a good enough excuse or is not a reasonable explanation. The fourth guiding principle relates to the claimant, and the test is both an objective test and a subjective test. So objective test is about a reasonable person. A subjective test then turns to the claimant themselves, and you'll hear terms such as, sophisticated or unsophisticated claimant, and that plays into what a reasonable explanation may be. I like to group 5 and 6 together, and those two prongs of the guiding principles discuss weighing of the prejudice to the insurer and the hardship to the claimant. Often, this is where you'll see the trier of fact or the adjudicator, um, you know, where the other guiding principles fail. You'll see the adjudicator discuss the balancing between the claimant and the insurer to come to a decision that shifts in whatever way they want to kind of decide the case. For instance, when you have a claimant that is CAT, you will find that oftentimes a balancing act will shift towards the claimant or in favor of the claimant because they have significant injuries. Now, in the past, Horvath is the case that is most cited when setting the guiding principles. For those of you who have been around before the LAT, this is a FISCO decision from 2012 or 2013. And truthfully, it's been the lay of the land for the better part of the last decade, right? In Horvath, the loss occurred in June 1999. We have Miss Horvath, who's a pedestrian walking in a shopping mall parking lot, and she gets struck by a third-party vehicle. The OCF1 is submitted a year and a half after the accident, and Miss Horvath's reasons are that she was unaware that she could apply for accident benefits through her own insurer because her vehicle was not involved in the loss. The result at the end of the day is that FISCO found that Ms. Horvath provided a reasonable explanation for her failure to abide by the timelines prescribed in Section 32, and she was not disentitled to applying for accident benefits. Again, even in 2019, it was similar, the lay of the land. In IG and Security National, we have a loss that occurred in 2014. OCF1s are submitted a little bit earlier in July 2016, and OCF18s were submitted in July 2016, but a completed OCF1 is not received until October of 2016. That's almost 2 years, very close to 2 years post-loss. And the reason for the delay, the applicant alleges, is that, she's unsophisticated, unaware of the accident benefit scheme, and ultimately really had no intention of applying for accident benefits until her injuries deteriorated. The result again, and this is a LAT case, was that she was not disentitled to apply for accident benefits. The LAT agreed that, her reasons were not that compelling, but they said that there was very little prejudice to the insurer. And they cited the consumer protection legislation and said that the issues should be determined on a substantive basis rather than on technical grounds. But really, there's been a shift in the past 1.5 to 2 years. And I would say that the shift began shortly after the LAT started taking a hard line on adjournments and procedural timelines. That's when the word adjournment really disappeared from the LAT vocabulary. When case conferences were not being adjourned, hearings were being set within 4, 5, 6 months of the case conference, and there was very little flexibility in those timelines. During that time, we started to see a shift in the way the LAT also started applying the guiding principles in assessing the delay that we talk about in Section 32. It seems that the stance that the LAT was taking on a procedural perspective with respect to delay was also translating into timelines set out in Section 32. Basically, the LAT has been taking a much stricter or firmer interpretation um, of delay. And initially, when Ankita and I thought about doing this presentation, we were going to summarize a lot of the recent cases for you. And when we started looking at the cases and pulling up the cases, we found that there were really too many to go through in this presentation. In the past 6 months alone, um, and I have listed the cases here, and Kita and I have reviewed them and summarized them, but we won't bore you with all the details. There have been almost 30 cases or decisions from the LAT on this issue in the last 6 months alone. So we've done the legwork for you. We've summarized the cases and we're ready to plop them into your next preliminary hearing issue or motion materials. But the Coles note is that for the most part, the insurer has been overwhelmingly successful in advancing this preliminary issue and having the applicant's claim barred or having their application for accident benefits barred. I would say that in the 30 cases in the past 6 months, the ratio is in the ballpark of 9 to 1 in favor of the insurer. The odds are really in favor of the insurer, and some insurers have been at the forefront and much more active in advancing this issue. But my recommendation would really be at this point to advance this preliminary issue if you have a delay with respect to Section 32. It's not like where we were a few years ago where, I would very rarely recommend to the insurer to advance this issue if we were not talking about a 1.5 or 2 year delay. At this point, even if we're talking about 30 days, 40 days delay, it's worth looking at the facts and discussing whether or not this issue should be advanced. There are cases out there that, circle around a very short time frame in which the claimant submitted their OCF1 relatively soon after the time frame stipulated in Section 32. Again, it's very fact specific. The past LAT cases are not binding, and the LAT, as I like to say, is going to LAT. But at this point, would be a great time to start thinking about this issue and advancing the issue of delay because the cases are in our favor. So why not advance this issue? Um, Without further ado, I think I'm going to turn it over to Ankita to discuss some interesting cases that she's found, and then we'll talk about some practical tips.
Thank you, Mai, and thank you for the kind words earlier. As Mai had mentioned, we, did look through approximately 30 decisions that was just released from the LAT in the past 6 months. But for today's purposes, I'm just going to summarize 3 decisions for you. First and foremost is the decision of SABAG and St. Paul Fire Marine Insurance Company. This decision was recently released in April 5th, 2024, and it was held or heard via a preliminary hearing via written submissions. Here, the applicant was an occupant of the megabus that was rear-ended in a rear-end collision on June 30th, 2021. The applicant had notified the insurance company here by submitting an OCF1 on February 2nd, 2023. So there's approximately a 19-month delay here. When asked for the reasons for delay, it's pretty much twofold. First, he was an unsophisticated litigant who wasn't aware that he could actually make an accident benefits claim while on a commercial bus. Second, he was not, because of that, he was not aware that he can do so by February 1st, 2022. As such, once he found out that he could actually do that, he had a very difficult time to find out who was Megabus's insurance company, and his legal rep, even MVAC, had difficulty finding that out. Given that, he eventually found out that identity in January 27th, 2023, and that's when they submitted this OCF1. The tribunal here, first and foremost, actually looked at what the applicant's reasons for delay was in their statutory declaration. Here, the applicant had advised the insurance company, that his accident-related injuries had come up 2 weeks after the accident, and the tribunal was not impressed that he didn't, know that he can actually make an accident benefits claim when he found out his injuries were 2 months within the accident. Second, they acknowledged, he did have a difficult time finding out who the actual insurance company was, but it was not a reasonable explanation here because he did not put forth a reasonable explanation or a credible explanation as to why he didn't know he can make an accident benefits claim between the January 30th, 2021 to February 1st, 2022. So that's the accident date to when he realized he could make an AB claim. And tribunal was truly not persuaded by that argument. The applicant had not put forth any other evidence as to why there was such delay there. And the tribunal here said, the ignorance of law is not a reasonable explanation, as Mai had earlier mentioned. The key takeaway, honestly, from this case is first and foremost, get an EUO or a statutory declaration done. The tribunal does look at that, does look at the first reported reasons. When did he first realize his injuries were related to this accident? Second, create a good timeline for the tribunal to follow. Here, it was very key because when they did so, they realized there was no reasonable explanation for delay after that accident occurred until he found out he can actually make a claim. That being said, I would like to move on to the second case, and this is Garcia and Economical Insurance Company. This decision was released in March 18th, 2024, and it involved a pretty interesting set of facts here, where the applicant was on a break. On his employment break, and he saw a customer steal a box of wine. She went to go grab him, grabbed the box of wine while crossing the street back to work, was hit by a pickup truck. She actually suffered quite serious injuries to her right foot, had multiple foot reconstruction procedures. And eventually, insurance company here, Economical, found out about this accident and actually sent her an OCF1 in all the forms in May of 2021. The applicant acknowledged it, but no OCF1. In July 20th, 2021, an OCF3 was submitted by the hospital, actually, and Economical acknowledged it, but requested an OCF1. Still no response. Economical followed up multiple times and no response. It was until her second accident, she actually submitted an OCF1, and this was in April 12th, 2022. And this was approximately a 13-month delay here. And when the tribunal asked what are the reasons for the delay, she said, first and foremost, that she was just overwhelmed, scared, isolated, and she just wasn't able to complete her application as a result. Second, she just realized she didn't realize the severity of her injuries until the second accident occurred. Um, as such, the tribunal looked at this and said, sorry, this is not a credible explanation. First and foremost, the evidence demonstrated that in that time period, that 13-month time period, she was actually able to complete 2 employment insurance applications, a WSIB claim. She returned to work as a loan officer. She even told an EI representative that she had a good support system at home and her partner was helping her with stuff after the accident. When they looked at the hospital records, they saw that the social worker actually had provided her education and auto benefits. And all this and she even told an EI representative that, yep, she had the paperwork for accident benefits and she was going to do it. All this evidence, unfortunately, didn't help her credibility here, and the tribunal noted that. And in regards to her injuries, the medical records also demonstrated that she really did know her extent of her injuries. She even asked the doctor, like, hey, am I having psych issues as a result? And the medical records really didn't help in this scenario. Given this, the tribunal did not find that the applicant's reasons to be credible or worthy of belief. Again, the key takeaway of this decision is when you have such of a delay and their reasons for delay, ask for productions to verify those reasons. Here are the EI file. the medical records from the hospital, the WSIB file, all helped to see whether the reason for delay was in fact credible. Lastly, and I'm cognizant about the time, but I'll go through the last decision. Uh, and it's Shaver and Onlia Insurance Company. This was a decision actually where the tribunal did find a reasonable excuse. This was a decision where the applicant was a pedestrian and was struck by an unknown driver, and he didn't know who the insurance company for that driver was. His reasons for delay was quite simple. He wasn't aware that he can actually make an accident benefits claim to his own insurance company because his vehicle was not involved. Um, the tribunal first actually found that to be a credible, reasonable excuse. In doing so, they looked at his level of education, which was limited, that the fact that he worked as a laborer and a landscaper, and given these personal characteristics in that objective test that Mai was talking about, the tribunal was quite persuaded that he may have not actually known he was entitled to benefits. Um, but more importantly, the tribunal also looked at how significant his injuries were. Here, he had fractured both of his ankles that required surgery. He was in a wheelchair that needed crutches and a cane. Part of his EUO testimony, uh, shared that he was actually struggling with moving, with walking, with lifting. Given this, the tribunal found that the hardship to the applicant, there would be a hardship to the applicant if he was prevented from proceeding to the substantive issues in the hearing, and that there'd be farther greater prejudice against the respondent. Sorry, farther greater prejudice on the applicant compared to the respondent in this circumstance. And as such, on an equitable basis, the tribunal found that the applicant had provided a reasonable explanation. Um, this is quite interesting, right? In comparison to the first decision, where I talked about where the tribunal found that an unsophisticated party or an ignorance of law is not a reasonable excuse. But here, the tribunal found the opposite. And I think what's key is that the applicant appeared to be more credible. His version of events, his reasoning for delay were all pretty similar to what was the EUO testimony. And what likely bolstered the applicant's credibility here was the fact that he also had the injuries that I had stated, and that really assisted the applicant and appear more in a very sympathetic light. Um, and those are key things to actually look out to see, get those medical records. Or is his testimony very similar to what he's saying here in the hearing? With that being said, I'm going to move on to give it back to Mai to just wrap up and tell you some key practical tips as to how to use a Section 32 denial in the future.
Thanks, Ankita. Okay, so practical tips on what an adjuster should be doing or looking out for when you're considering advancing a denial of a claim under Section 32. The first thing I think that's really important when we reviewed all of the cases is that the timeline is very key. So an adjuster on the insurer's end really needs to make sure that the log notes are well kept. The initial conversation in the PD file where an accident is reported, that initial conversation needs to be recorded. The communications between AB and PD, there needs to be something there when there is a claim or the claimant tells PD that there are injuries, there needs to be some follow-up from the AB with the package going out. And then again, initial communications with the insured, with the claimant. That timeline is very helpful. I know that each insurance company does their adjusting and log notes a little bit differently, but it's really important to have that document that typically is the only document that provides a timeline on the insurer end. When you do get an application that's late, a few things that you want to consider is the statutory declaration as soon as possible. Consider an EUO also as soon as possible and get those medical records. We want to get the version of the facts to figure out if the credibility is there and if and when we can advance a preliminary issue. So those are basically the practical tips on file handling for these cases. We're happy to open the discussion now to any questions and answer or questions that anybody has or wants to get answered. Again, there is a prompt where you can just type in your question, and Keita and I will be happy to field some of them. We have about 5 minutes left, so maybe a few questions. Um, okay, so I'm going to tackle the first question here about um, what type of time frame or delay are we looking for before we can consider advancing a preliminary issue with respect to Section 32? I would say that, um, if you're looking at a delay that's 30 days, if you're if you're getting notice of an accident 30 days after, 45 days after, you're in a good position, assuming that the facts are good, to advance a preliminary issue. There are some recent cases. Hajazi and Economical is one, and there's another one, Woods and Economical. Both those cases, the LAT found that there was no reasonable explanation for the delay, and in both those cases, the delay was roughly 45 to 60 days. So we're talking about quick turnaround these days. And again, everything is fact specific, but there are some cases on your side, even with short turnaround. And Kita, do you want to get the next question?
Sure. I guess I see another question here that says, are there any other reasons that the tribunal has found to be a reasonable explanation? As Mai has kind of mentioned earlier, uh, you know, the we found that the trend is that when there's cat involved, catastrophic injuries involved, the tribunal's much more sympathetic and will likely to pass and turn a blind eye, I suppose, on that delay of whatever it may be. There's actually one decision, Muhammad and TD, and that delay was 2 years. But because the injuries were so severe, um, and there being cognitive issues there, a brain injury, the tribunal did say, you know what, there's more prejudice on the applicant here opposed to the respondent, and that's why they said it's a reasonable explanation. Another trend I found is that it's when situations where there is a death in the family and the family member had applied for accident benefits, mainly being a funeral benefit or death benefit. In those cases, the tribunal is much more lenient, again, on the sympathetic side of things, saying, you know what, insurer, you kind of knew you were been told that was an accident as a result of this, and as such, you should have the obligation to provide those forms, and you didn't do so, and it's reasonable that the individual here did not know he can apply for accident benefits. But I did find those are the two main kind of reasons that I've noticed in our trends here. Um, but yeah, no.
Okay. Doesn't seem like we have any more questions. We're a couple minutes early, but that's fine. If anybody does have any additional questions that they want Ankita and I to field, we'd be happy to respond to them via email. But I am going to give everybody a couple minutes back into their afternoon, and we are going to end, well, now we're ending on time. So I hope that everybody has a great rest of the day, and we look forward to chatting and meeting with everybody next time.
Thank you,
Thank
everyone.
you.